Hi guys. Okay, the integration of the national heritage includes elements such as the artistic, cultural, archaeological, and other heritage, while the state fiscal heritage in principle in charge of the government authorities is also in charge of the public ministry. In a broad sense, the Charter alludes to the concept of heritage when it speaks of the cultural, ecological, and archaeological heritage of the nation. Article 63 establishes the assets of public use, natural parks, communal lands of ethnic groups, the lands of reserves, the archaeological heritage of the nation, and the other assets that the law determines are no sold, no prescription, and do not cease.
Corporation has understood that the notion of public patrimony includes the assessed rights, interests, and obligations of the state, which involves responsibilities and duties. It understands by public patrimony totally of assessed rights and obligations of which the state is the owner, which serve for the fulfillment of its attributions according to the positive legislation. Its protection seeks that resources of the states are administered in an efficient and responsible manner, as provided for in the Bodger rules. The legal regulations of the defense of the patrimony has a guaranteeing purpose that ensures the normative protections of the collective interest. Consequently, all public activity is subject to such control, which, if affects to the public patrimony or the other collective rights, may be subject to judicial analysis by means of the popular actions. For the court, the due management of the public resource, good faith, and the collective rights to the defense of the public patrimony from the principle of administrative morality.
This patrimony can be used free by a person with the restriction imposed by the entire responsibility of the assets. Example, bridges, square, rule, all waiters, user, and property of the state, they are collect right and interest, among others, to read to do. They enjoy of public space and the use and defense of property of public use, the defense of public heritage, the defense of cultural heritage of national. They are subject and regimen provided by public law, which regular the use and enjoys of the resource.
All the activities carried out by the state in the different branches of public power and state organs may generate responsibility at their charge. Since the agents who carry out these activities can cause damage to the administrator, which must be repaired. The patrimonial responsibility of the state in Colombia acquires a constitutional basis from the issuance of the political constitution of 1999 and 1991. Until then, there is no constitutional provision that would expressly contemple the state's obligation of reparation. This here of eminent jurisprudential creation whose evolution was progressive. The Constitution of 1991 introduced in the Colombia legal system for the first time, constitutional basis of the patrimonial responsibility of the state. The current constitution expressly recognizes the patrimonial responsibility of the state.
Article 90 of the Constitution establishes the state is financially liable for the unlawful damage that are attributed to the cause by the action or omission of the public authorities. Article 19 is the trunk on which all the patrimonial responsibility of the state is based, by contractual or extra-contractual. The patrimonial responsibility of the state has a principle of integral guarantee of the patrimony of the citizens, enshrined in our Constitution order in Article 2, which indicates the obligation of the state to protect all the people who reside in Colombia in their life, honor, and property. In Article 58, which guarantees private property and the other rights acquired in accordance with the law, and Article 90, which is the basis of the extra-contractual liability of the state and which establishes the general clause of patrimonial responsibility of the state. The liability regime enshrined in the Constitution has two central elements: the notion of lawful damage, its imputation to the state, which we will explain in future videos.
Continuing, where my partner says, among its most important characteristics are, is a subjective and personal, to the extent that the ownership of the right to formulate such claim is recognized to the person who has suffered unlawful damage due to certain administrative actions, and for such can demand compensation in accordance with the provisions of the law. It is of non-contractual liability, because it originates in situations in which it does not depend on the manifestation of the will of the administration, but on phenomena or events such as facts, operations, and administrative omissions that cause damage to individuals or public entities. The term to exercise this claim is 2 years from the day after the administrative action or when the interested person has knowledge of it, as long as the impossibility of having known it at a later date is demonstrated. It is of a patrimonial nature, since it seeks to repair the damage that were caused, either to individual or public entity. That is nature imperfectly compensatory or of both material and immaterial damage. The procedure agrees with the ordinary procedure enshrined in the Code of Administrative Procedure and Administrative Litigation.